See, due process of law, and then it says that the disqualification shall not exceed 5 years from the date of declaration.
I'll tell you what Parliament did.
Parliament has.
उन्होंने कहा हम इसको बस छोड़ो, इस बहस में पढ़ो नहीं, 5 साल कर दो, खत्म. That's in a nutshell what Parliament did. अब we can't tell Parliament to craft a law this way because in my mind this is the best way to proceed. This is their job. Our job is another job. Is it unconstitutional?
My lord,
the one proposition was put forward: do not touch upon 232. You may need to touch upon 232 at another juncture. I'm just speaking aloud for myself, I tend to agree with that. Nobody has challenged it. We assume it's okay till someone comes and attacks it. Maybe it's a very good attack. I don't know. Maybe they say, 5 saal bhi kyun? I don't know. Let's leave all these things. The fact is someone has applied their mind and made a law. And that law specifically mentions all judgments of any courts. So that law has shown us respect in the sense that they have just, like my Honorable Justice Afridi has said, for the not lifetime thing. So they have kind of brought it about by this legislation 5 years over. अब ये बहस किसी और दिन के लिए रखेंगे हम, अगर जरूरत पड़ेगी या नहीं.
ये ठीक है. And then also this important question.
What do we say about declaration?
Now,
it seems that at the time of Samiullah, the court was pushed to do the work of the parliament, and now again it is being presumed that we will do the work of the parliament.
And court has not said for the permanent disqualification, it is only as long as the declaration will remain in field. Again, I will put you this question: why the section 232 cannot fix the period of that declaration?
it can, sir. Because, and I respond
Then
to
there
this.
is no
It can, sir,
inconsistency between the Samiullah and the Act.
Because 62(1)(f) has two components. One is preceding clauses of Article 62, if applied strictly, are probably incorporated in the Constitution to ensure that only the pure and pious Muslims living up to the standard of a prophet of God Almighty should be elected to our assemblies, so that, as provided in the preamble, the sovereignty of God Almighty could be exercised by them in the state of Pakistan as a sacred trust. But instead of being idealistic, the constitution of a country should be more practicable. The line of prophethood has long been discontinued, and now we are left with sinful mortals. The political arena in our country is full of heavyweights whose social and political credentials outweigh their moral or religious credentials. Even the electorate in our country has also repeatedly demonstrated their preference for practical wisdom and utility over religious Puritanism. Thus, the inclusion of unrealistic and ill-defined requirements in the basic law of the land renders the same impracticable and detracts from the sanctity which the Constitution otherwise deserves. Now, coming back to the question of possible conflict between the provisions of Article 62 dealing with qualifications and those of Article 63 dealing with disqualifications, one such example of seeming conflict can be found in the provisions of Article 62(1)(g) and 63(1)(h). 62(1)(g) provides that a person shall not be qualified to be elected or chosen as a member of Majlis.
This learned judge has given a categorical finding of the 7-member bench. Justice Jawad Khwaja says we'll consider it appropriate time, but Justice Asif Saeed Khan Kosa gives a finding.
With regards to...
It's a finding, clear-cut finding.
Yeah.
Okay, we cannot do this exercise.
We cannot do this exercise.
Has Khwakwani was discussed in Samiullah Baloch?
No, sir. No, sir. No, sir.
I find that a bit strange.
It is quite so, sir.
Because this is not, it's 2015 and,
That's right.
and Samiullah is?
It's 2018, sir.
So it's soon after.
Yes. And I don't know if any of the members who were part of this bench were also part of Samiullah. I suppose not.
Yes.
What about the majority judgment? You see the question or the majority?
Majority opinion, my lord, these were additional. The unanimous decision, these are additional notes.
ये additional notes हैं. The majority didn't touch upon this.
जी 289 to 90 पे वो खत्म हो रहा है, वो कुछ नहीं बात की
चार
इस पे नहीं की.
4 सवाल उन्होंने फ्रेम कर दिए,
छोड़ दिए. अच्छा
सर साहब ने कहा कि इसको हम देखेंगे appropriate case में.
What was the case about?
My lord, this case Ishaq Khaqwani, my lord, this was
कोई disqualification.
जी disqualification का case था. It was Ishaq
I mean, it was
Khaqwani.
directly in point.
Now,
Didn't do it anything.
Now you want us to decide these questions.
my lord, this is a very important question. First and foremost, the declaration by which court of law, my lord the Chief Justice, on the first date of hearing, had observed that while referring to Article 175, clauses 1 and 2, that the Constitution envisages three sorts of courts. Well, there's a Supreme Court, High Court, and the courts established by law. And then the jurisdiction exercised by these courts are either conferred upon them by the Constitution. In the case of Supreme Court, all jurisdictions are conferred upon it by the Constitution. In the case of High Court, it's the original constitutional jurisdiction under 199 is conferred by the Constitution, but by law, jurisdiction can also be conferred upon it. And then there are courts which are established by law itself.
No, but there is another constitutional court which you've not mentioned, which is the Federal Shariat
Yes,
Court.
Federal Shariat Court,
And the
of course.
Federal Shariat Court has exclusive domain of determining Islamic matters.
That's right, sir.
And
It's
some of
treated
these
as-
clauses pertain to exclusive Islamic domain.
G. 175 doesn't make a reference to Federal Shariat Court.
Why is that court not the appropriate court then? It deals with Islam, so that should be the appropriate court.
It could be, but then when we examine what that declaration could be and under what law would
It's
it be,
unworkable.
then we have to then see whether it is Federal Sharia Court, in fact, which can give that sort of declaration. I mean, if it is a civil declaration, for example,
अभी
if...
फेडरल शेयर कोर्ट में ये क्वेश्चन गया है आपके इंफॉर्मेशन के
नहीं
मुताबिक?
जी, नहीं. So if I may, if the dispute is inter se two parties, it's a private civil dispute, and a dispute is decided by deciding a dispute, a finding comes out. I don't know how conceivable would it be, but let's say, for the sake of argument, a finding comes out that a person dishonestly not honor its contract, and that finding.
टू डी डिसाइड ही नहीं हुआ इस जजमेंट के अंदर,
जी सर, नहीं.
मेजॉरिटी में भी नहीं, ये भी नहीं कहा किसी और केस में देखेंगे.
वो ये तो कहा कि किसी और में देखेंगे, ये जो ABCD था, but Justice Jawad Khwaja observed that in an appropriate case we'll examine it, but then it was never examined.
अब देखिए D जो है talks about Islamic injunctions. E talks about Islamic teachings, Islam. F though does not mention Islam but kind of brings in the concepts which are recognized in Islam. Now, would this not then be in the domain of the Federal Shariat Court? No court has ever even considered Federal Shariat Court to be competent in this regard.
Could be, my lord. Could
I don't know.
That is something.
I'm just posing a question.
Gee, I mean, but when we look at a little bit of, if I may take you through.
अब उनकी jurisdiction Federal Shariat Court की on hudud and Islamic injunctions पे.
My lord, there is another aspect.
So I don't know. I mean, it's a very
इसका एक थोड़ा और एस्पेक्ट भी होगा. वो एस्पेक्ट ये हो सकता है, फॉर एग्जाम्पल, अंडर penal code section 403, a person who dishonestly misappropriates property. Now there is an element of dishonesty while misappropriating property, and it's an offense, punishment of which is up to 2 years.
which some other person has mentioned earlier, then you will be convicted, plus you will be disqualified for life because you're dishonest.
Right, and if the punishment was more than 2 years, so फिर 63(1)(h में आ जाता है कि ये moral turpitude हो गया, तो बस
This
वो
is
2
what I
साल.
wanted to ask कि moral turpitude में कौन-कौन से offences आते हैं?
Your ladyship, now this term was examined in Samiullah Baloch, and if I may draw your attention to paragraph 26 of Samiullah, they actually, after examining various definitions and meanings, Samiullah then holds that page 432 of PLD 2018, Supreme Court 405, page 438. So moral turpitude's non-exhaustive definition was, so to speak, was provided in Samiullah.
No, but considering that Ishaq Hakwani leaves the question open, but then Samiullah does refer to civil original
court.
jurisdiction,
Yeah.
and they've tried to do that. So they've carved out one, but there too a declaration can't come to this effect, but they've said as a consequence we'll be building that. So is your argument that this is yet not sorted, that unless a procedure is put in place or some sort of
So three
don't know how
things.
to really get
Three
this
things,
declaration.
three things actually, all four of them. So let's say a court can be now, Samiullah says it's a court of civil jurisdiction.
Right.
To my mind, it could be a court of criminal jurisdiction as well.
Right.
As I gave an example, cheating, for example, under Penal Code Section 415 is an offense. Section 417 says that punishment is up to 1 year. Now, up to 1 year doesn't get covered under 63(1)(h). But if a person is
criminal breach of
trust है, उसकी punishment ज़्यादा हो जाती है, वो शायद 63(1)(h) में गिर जाएगा. But anything which is less than 2 years obviously doesn't get covered under 63(1)(h), but can very well fall under 62(1)(f) for that. For sake of what court could it be? It could be
No,
any
no,
court.
so what are you submitting? You're saying that whatever Samiullah has come up with, that is also not correct.
That's not correct.
And unless some procedure is laid down by perhaps the legislature as to what kind of declaratory orders could or declaration could come out, which would meet the requirement of 62, till then there is no declaration.
My lord, yes. My lord, a question was raised about 62 and 63 and their interface. And in Sabir Shah's case, 95 Supreme Court, 97, the Supreme Court says that 62 applies at pre-election stage and 63 applies at both pre and post-election stage.
citation there, Sabir Shah.
Sir, Sabir Shah is 95 Supreme Court, page 66. And the relevant page
Can you
is
repeat the citation?
PLD 1995, Supreme Court 66. And the relevant page is 274, sideline YYY.